Welcome to Court TV on Crestview Community TV. I'm Ryan Hardy, your Crestview Community TV legal analyst, and today you're watching Docket Day. Now, Docket Day, last year and in previous years, it was the biggest court date. Now we've added a court date with pretrial conference happening the week before Docket Day, so Docket Day has shrunk down and gotten somewhat smaller. However, you're still going to see defendants who maybe have been in court for the first time, maybe their appearance was waived at pretrial conference, which we spoke about in that video. But when someone's called to the podium, you're going to see, again, one of a few things can happen. They can enter a plea. At that point, the case would be over, and they'll get sentenced either today, live on Crestview Community TV, or they'll get sentenced in a sentencing hearing down the road on one of those miscellaneous dates that we'll talk about in another video. They could also ask to continue the case. At that point, it would get set to another cycle 6 weeks down the road. The last thing they could do is they could announce ready for trial. And that means, hey, we're ready, when we're going to send this case to a court date called jury review. And then from that point, the case will get sent to a jury trial. And I know that's what we all really, really love to see. Those obviously are rare. They don't happen a lot. But we all get excited when we hear that, ready for trial.
So I've spoken with him this morning, Your Honor. Michael Gilbert on behalf of Donald Langley and 23 CF 74, 15 CF 129, and 15 CF 307.
Okay.
Defendant is present. And we request a continuance, anticipate resolving it next cycle.
No objection, Your Honor. December 7th would be fine with the state, 9 a.m.
December 7th, is
No
that okay?
objection. That's
All right,
great.
thank you. Thank you, sir.
Thank you. Thank you, Your Honor.
Mr. Patel?
Good morning, Judge.
Morning.
Jay Patel on behalf of Jonathan Wayne Brown.
All right, what you want to do?
And Judge, if we can set this to the next pretrial, I don't believe there's any objection by the state.
No objection, Your Honor.
All right, February 26th.
Is there a December date?
Well, we have December 7th for miscellaneous. You said pretrial,
I did. February's fine.
February
Mr.
26th.
Patel, if we have an agreement, then we can set it sooner
Correct.
than that.
That's right.
We'll say February 26th, move it up if you can.
Yes, sir. Thank you,
Okay.
Judge. May I be
Thank you.
excused?
Yes.
Thank you.
Good morning.
May it please the Court, Your Honor, Brad Stewart present. Judge, the first client I have on your docket is Thomas Haney. Mr. Haney is present, Judge. I would like to just pass that to later on this morning if I can. Need to chat with Mr. Haney a little further.
Oh, you mean just later this morning?
Yes, sir.
Okay, all right. Okay,
My next client is Mark Perez, Judge.
okay. All right.
Brad Stewart on behalf of Mr. Perez, for the record, Judge, this is 22 CF 1529. And Your Honor, if I may pause for a moment while the state signs plea agreement.
Okay. You are Mark Andres Perez?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for his courts are true, so help you God?
Yes, sir.
Thank you.
Your Honor, may I approach?
Yes.
Your Honor, at this time, Mr. President is prepared to admit the violation of probation with the understanding that there will be a modification to occur by modifying probation to extend existing supervision for a year for a total of 3 years of probation. You must complete the batter's intervention program within the first 12 months of being put back on probation and complete all outstanding original requirements.
Has he been adjudicated already? All right. Mr. Perez, did you read and sign this plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this violation of probation admission?
Yes, sir.
Has anyone forced you or threatened you to enter this admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Stewart's done for you on your case?
Yes, sir.
Court finds the admissions freely and voluntarily entered. Court accepts it. Court will modify probation by extending existing supervision by 1 year. For a total of 3 years probation, you must complete batter's intervention program within the first 12 months of being put back on probation and complete all the outstanding original requirements. And that was State of Florida versus Mark Perez, 22 CF 1529. Okay? Thank you.
Your Honor, from probation standpoint, we're going to extend 1 year from his original termination date of March the 5th, 2025 to March 5th, 2026. Is that correct?
Total of 3 years, yes.
That's fine. I'll waive cost of supervision. Thank you.
Your Honor, my next client is Mr. Anthony Roca, Judge. This is 21 CF 3271. Mr. Roca is present. Your Honor, we previously set this case for trial. We do have a motion in limine that was filed that is set for this afternoon at 2:30.
Okay.
So we'll be back this afternoon, Your Honor.
Okay. Is it still set for trial, or?
Yes, Your Honor. And Judge, I can stick around. I know we've got a number of cases that are
Yeah,
set for trial.
because
I'll be happy to stick around this
we
morning.
may not have enough days. If you said 4 days,
Yes, Your Honor.
you know, think jurors probably get aggravated if they're here on Thanksgiving Day, you know,
Absolutely, Your Honor.
you don't want aggravated jurors, you know.
No, Your Honor.
So, okay. So hang around and we'll see what happens this afternoon.
Yes, Your Honor.
Okay, thank you.
Please, we need him. Your Honor, my next client on the court's docket is Mr. Alvin Williams.
You're Alvin Latrell Williams, sir?
Yes, sir, I am.
Okay, very good.
Judge, we're gonna move this to December 7 for right now, by agreement of the state on the miscellaneous date. And if we can bring it in for a landing prior to that, I'm gonna try to put it on the 9th.
Okay, thank you, sir. Thank you.
Your Honor, that's all I have at the moment, if I may be excused.
All right. Ms. Rivers, then?
Yes, Your Honor. Your Honor, I have 2 people, they're in custody, and 1 person out of custody. If I can do him, wait.
All right.
Your Honor, I have Devin Robbins. He's number 32 on the original docket.
Okay.
21 CF 23, looks like 2399. 23 CF 2891.
All right.
And Your Honor, we are set for trial in this matter.
Okay.
Still in trial posture, Your Honor.
We'll set him for November 20th. You said 3 days, didn't you?
Well, Your Honor, we were having a discussion of possibly, you want to approach?
Do what?
May we approach, Your Honor?
Oh, okay.
Hello, this is Chris Norman at Bulldog Bail Bonds. Our office is in Crestview, Florida, but we service 7 Northwest Florida counties. If you ever find yourself in a jam, please give us a call. We're here to help you out.
Congratulations, Crestview's very own Dixie Dan Powell of Powell Injury Law, for your recent jury verdict of $11.5 million for your client from a death and injury against an inflatable amusement company. Recognized in 2017 as one of the top 100 civil trial lawyers in the state of Florida, and Dixie is AV Preeminent rated. Dixie Dan Powell works tirelessly for his clients, as is evident by this extraordinary verdict. If you're taking your case to trial, be prepared. Contact Dixie Dan Powell and Powell Injury Law, 850-306-2667.
Get you tried this month.
That's fine. Next is Stacy Wilkerson.
Stacy Wilkerson.
Your Honor, we've reached an agreement in this matter, if I may approach.
All right. You're Stacy Lynn Wilkerson?
Yes, sir.
Would you please raise your right hand and be sworn? You swear the testimony you give for this court's true, so help you God?
Yes, sir.
Thank you. All right, Ms. Wilkerson, you want to enter a this is State of Florida versus Stacy Lynn Wilkerson, 21 CF 847. You want to enter a no contest plea to the charge of possession of a controlled substance, a third-degree felony, and possession of drug equipment, a first-degree misdemeanor, correct?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs prevent you from knowing what you're doing here today?
Sir.
Are you happy with the work Ms. Rivers has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. You're judged guilty. Sent to 5 months Okaloosa County Jail. And is that?
She's currently serving a prison sentence.
Oh, okay. I was going to say I can't sentence her to 5 months DOC. Okay, well, it's concurrent with your
Prison sentence that she's currently
all right.
doing.
The 5 months Okaloosa County Jail is concurrent with your current Department of Corrections sentence. With credit for time served, $5.15 court costs, $100 cost of prosecution, $150 PD fee, cost to collections, and the state's not going to take any action on the failure to appear, correct?
That's correct, Your Honor.
Okay. All right, do we have a score sheet on this?
I'm going to file it before the end of the morning.
All right, thank you.
Good luck, John. Thank you. No, it's a failure of the PTI.
Okay.
PTI failure.
All right, so here's what I'm going to turn to the document. Are you ready?
Yes, I am. Okay.
Is this Zelm, Terry Ann Marie Zelm?
Yes, Your Honor, 19 CF 2237. Your Honor, she was sentenced last week. The jail would like for us to add on her sentence the wording bars to bed. Otherwise, they'll release her. And she's scheduled for pickup from Phoenix House on Wednesday.
Was that part of it? Okay, we'll modify that sentence to bars to bed.
And Your Honor, just for Ms. Zelm's credit, she was released on Friday. She did show up at our office. We contacted the jail. We were able to get her back into custody, so she really did do the right thing.
All right, well, very good.
I better let the court know.
Yes, you should be. And Wednesday, I called and they said they already have you on the list for Wednesday pickup. Okay.
All right, thank you.
Good luck. Your Honor, this is Rusty Rogers. He's before the court on 22 CF 000060, 23 CF 1681, and the reason that he is back is 19 CF 2691. We spoke about this case last week, Your Honor. It was not open in the clerk's website, and we're trying to figure out how to get the case open. And Madam Clerk, is it officially open now, or is it still pending? Basically, what we had determined last week is he was served the paperwork for the violation of probation. However, the clerk's office never got any of the information. It's open now? Okay. Thank you. So at this time, we would like to enter a denial to the violation of probation, and we'd like to put all his cases on the next docket. He has 2 VOPs and 1 new law, Your Honor. Oh, you want to put it on December 7th? December 7th is fine.
Okay, December 7th.
Okay. All right.
Mr. Flaherty, Tim Flaherty, Miss Merrifield. Okay.
Brandy Merrifield and Tim Flaherty on behalf of Jared Skiles and 18 CF 3045. As the court may recall, this case was set for trial. We had anticipated proceeding on 11/13. However, we are seeking a continuance. There is an exceptional circumstance that has arose. We were informed by ASA Sandler on Saturday morning that the medical examiner, which is a critical witness in this case, was in a tragic accident. It's my understanding that he is still in the hospital. We don't have an update on his condition. He's certainly unavailable for trial at this point. So we would move to continue on that basis, as well as ASA Sandler was able to have a piece of evidence tested that was not previously tested. We were provided some details about that, but we have not been provided a report, so we would need the opportunity to review that report and have our expert analyze that as well. It's my understanding that under the exceptional circumstances, the state is not objecting to this continuance.
Ms. Sandler has no objection, Your Honor.
What about February 26th?
For pretrial, Judge?
Yes. Okay.
Thank you, Judge.
Thank you, sir.
Thank you, Your Honor.
Appreciate it.
See you soon, dear.
We'll come see you.
Mr. Hardy, are you, okay.
Your Honor, I have a few out of
Mr.
custody, if I may.
Gibbs, okay.
Thank you. Judge, out of custody first, I have Mr. Horace Durden.
What was his name, please?
Horace Durden, Judge. Number 28 on my docket, Judge.
All right, Horace Durden. Very good.
Judge, we're requesting a continuance in this case. We do need to depose the alleged victim before trying to proceed to trial.
February 26th.
Thank you, Judge.
All right, thank you, sir.
February 26th. Next, Judge, I have Mr. Brandon Eastlick. Your Honor, Mr. Eastlick is present and approaching. This is 23 CF 1456. Judge, we'd like to move this to November 30th for a status. We're going to be trying to get in touch, or the state's going to be trying to get in touch with the alleged victim in this case to see if we can resolve it.
November 30th. Thank you, sir.
All right, get an appointment before then. Next, Judge, I have Kelly Ellis. Your Honor, Miss Ellis is present and approaching. This is 23 CF 1453. I'm sorry, Judge, this is 22 CF 1842. I was looking at the wrong case. Judge, we'd like to request a continuance. We're going to try to depose the alleged victim in this case.
No objection.
You want to go to, when do you want to go to?
The December date or the February date's fine with me, Judge.
We have cases December 27th?
A handful already.
All right, December 27th.
Very well, thank you, Judge. And I have another out-of-custody judge, but we're working on an agreement on that one.
Okay. Is Mr. Williams here today?
I am, Judge.
Oh, okay. You got cases?
Yes, sir, I do. Mark Cook to Lyons.
Art Cook to Lyons.
Judge, let's leave this on the docket.
For trial.
Yes, sir. It's 23 CF 290.
Is this a one-day trial?
Judge, I certainly don't
Excuse
think
me.
it's more than one day. I want to say when we brought it up last time, there was one case the state thought was, well, it wasn't this one. This is yours. All right. This case shouldn't be more than one day trial.
All right, well, excuse me. I think we'll pick a jury.
Pick them all on Monday and then...
Well, let me think about this for a second. Thinking November 13th, excuse me, is a Monday. And pick a jury and then have him try his case like the next day.
All right, Judge.
What I'm thinking about is picking 3 one-day trials. Do we gonna have several one-day trials? Ellis and Valentine and Cook to Lyons?
Well, Your Honor, we have the one with Mr. Stewart that's going to take 4 days.
Oh, 4 days?
Yes. So,
Well,
Judge, I will say, in all candor to the court, we have waived speedy trial previously on this case, I believe. Yeah, I see we continued it back on August 28th.
is Kelly Ellis and Miranda Valentine going to go to trial?
Kelly Ellis was just continued, Your Honor.
Was it? Oh.
Yes. Miss Valentine's case hasn't been heard yet.
Who represents her?
Mr. Gibbs,
Where's he at?
probably speaking with his clients. I'm not sure.
Well, we've got November 20th. That's a Monday, I believe. pick a jury then and try it the next day?
That's fine, Judge. Whatever works for the court.
All right, so November 20th. Who's the prosecutor on that?
It's me, Your Honor, on this one, yes.
We'll pick a jury and either go right into it or try it or the next day, Tuesday.
Yes, Your Honor, because that week I know you sat the one with Miss Glisson and Miss Rivers.
All right, November 20th. About how many jurors you think you need?
This one, 40 at most.
You want to pick the jury on November 20th?
That's fine.
It'll be six peremptories each,
Yeah.
so that should be fine, and the 20th is fine for us, Judge.
And probably start Tuesday.
Yes, sir.
And 40 jurors. Okay. All right. November 20th.
Thank you, Judge.
Okay. All right.
All right, sir.
Next one.
Desiree Lige. Judge, the case has got some legs on it. Give me just 1 second. Judge, after brief consultation with my client, I'll go ahead and announce ready for trial.
All right. We'll pick a jury on November 20th.
This wasn't set for a clear trial. Mr. Williams has not spoken to me. All is not set for trial.
It's not?
Judge, I thought that we had listed it, but if that was not the state's understanding and they're not prepared, then...
February 26th.
All right, Judge.
All right.
Sorry, Judge, I'm trying to pick the ones that are out. Darius Livingston.
All right.
Judge, actually, what I'm going to ask is that we pass Mr. Livingston and give me a couple of minutes to talk with him here today.
All right. We'll bring you back in a little bit, Mr. Livingston.
Thank you, Judge. Tyler Moore.
Tyler Moore. Okay.
Judge, I believe this was passed for him to take the offer. I'm just looking for the signed copy.
Mr. Moore, would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God?
Yes, sir.
Thank you. This is 23 CF 1478, State of Florida versus Tyler Lee Moore.
That's correct, Judge. Okay. Mr. Moore, you mind if I date this for you? No, sir. Mr. Moore, yours? No. Yours, okay.
All right, Mr. Moore, you want to enter a no contest plea to the charge of grand theft, a third-degree felony, correct? Is that right?
Yes, sir.
Did you read and sign this plea and sentencing agreement form?
Yes, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Mr. Williams has done for you on your case?
Yes, sir.
Court finds the plea is freely and voluntarily entered. Court accepts it. Court withholds adjudication. 12 months probation concurrent with Santa Rosa County, Florida case. To have a substance abuse and treatment, no alcohol or controlled substance without a prescription. 25 hours community service work. Stay away from 2961 Adams Road, Crestview. Reserve jurisdiction regarding restitution to Matthew Knoll. 415 court costs, automatic early termination of probation if no violations, and all conditions completed after 6 months. So get this things done and your probation will be done in 6 months.
Yes, sir.
Okay? Thank you.
We ask the supervision fees to be waived, Your Honor?
Yes.
Thank you, Judge. Judge, I think all I've got left are in custody.
Okay. Mr. Hardy?
My first case is Timothy Holt, Your Honor.
Holt. Okay.
Always. Your Honor, Ryan Hardy on behalf of Tim Holt. Your Honor, we're going to ask to set this on the November 30th docket. We've got a couple of motions to file, and I think they may take care of this case.
November 30th. Thank you, sir.
Your Honor, my next case is Brandon Pursley. State and I have been negotiating. Your Honor, we'd like to get this on the soonest miscellaneous date we can get. If that's the 30th, we'll take it. If there's one in between, we'd take that as well.
30th, November 30th.
We'd like to set this on November 30th.
Okay, thank you.
Thank you, Your Honor. That's all I have.
Thank you, sir. Mr. Nopes?
Judge, the first case I've got is Louis Austie. He's an inmate. Judge, on Mr. Austie's case, the state and I really thought we had it resolved, and then they had to contact, the victims and what have you, and there's been a problem in the plea offer that they had thought they could be in a position to make. So I just need to continue the case, and honestly, the next trial cycle, I think that this case just needs to go to trial.
Send that to me on February 26th.
The state will send that, I guess.
Yes.
What's the date, Judge?
February 26th.
Thank you, Judge.
Y'all get it resolved, we can move it up.
Judge, the next case I have is Andre Copeland. If he's present, he has been meeting with Dr. Harper, and I emailed and asked if she had met with him enough to where she could render a report. She didn't respond. Just think, let me just continue it, and I'll email her again. I know he's been in contact with her.
February 26th, move it up if you can get it resolved.
This is the last continuance. We've been waiting on this evaluation for over 18 months. I understand it's not Mr. Noakes' fault, but we want to get this moving.
Yeah.
I understand.
Okay.
Last continue, that's fine. Judge, the next case I have is Judith Dickerson. Judge, I don't see her here. She may be outside. Let me just pass her, and I'll check on her in just a second, Judge. Stephen Jernigan is the next case, and Ms. Leone and I have agreed to continue it, and it's going to resolve itself.
No, Your Honor, I was able to review the file, and at this time, the state is going to dismiss the charges against Mr. Jernigan. We made several attempts to locate the victim, and the victim is unavailable.
Where's Mr. Jernigan at?
Judge, he wasn't able to be here today. He does on-the-road work for the union. In the state,
All right.
I told them that the other day. That
Well, file a null pros for us. Is that what you're going to do?
Yes, I'm dismissing the case, Your Honor. Yes.
All right, thank you.
Judge, the next case I have is Shailene Matthews, and she's an inmate. Judge, the state and I have kind of discussed a possible plea, but we want to have a sentencing hearing, so we haven't nailed down the terms. If you just want to pass it a little bit this morning, we might be able to nail the terms down.
Okay. We'll bring you back in a little bit.
Judge, the next case I have is Amon Robinson. I worked again this weekend in looking at the video. They did send a video, but I can't get it to play. And that video is going to be, I mean, he's either in the video or he's not.
Okay.
And I can't watch it at this point.
You want to go to December 27th pretrial?
Yes, please.
All right, February 26th. If he's, I guess if he's not in the video, then the case will go away.
I don't know that the state's committed to that, but in my mind, Judge, just based on everything I've read,
Okay.
They got, and my client understands. I told
All
him
right,
during the
thank
video,
you.
we got to resolve it.
February 26th.
Yes,
Thank
sir.
you.
Good. And then, Judge, the final case I've got is Mr. Scarborough. Judge, the state made an offer last week, and I met yesterday at length in the mornings with Mr. Scarborough and his family. Judge, we just simply are not in a position that we can accept the state's offer. What we would like the state to consider doing is to give us a plea to one-count sexual battery, and that be it, and we set it for hearing for the court to decide the sentence. And I don't necessarily know that the state's in a position to do that.
Well, y'all want to go to something like a miscellaneous day on December 7th or something?
You said December 7th?
If he pleads to the court or whatever, make sure he knows what the maximum sentence is, and, you know.
Judge, December 7th is clear on my calendar.
December 7th?
Yes, sir.
And the minimum sentence. I mean, I don't know. I haven't heard I don't know anything about it yet as far as what y'all are going to argue. I haven't heard your arguments, but 2 o'clock on December 7th.
Thank you, Judge, and then I may come back on, we'll come back on Matthews.
Mr. Powell?
I think it's 4623. I don't have the case number right now.
It's 23140, Jessica Taylor, correct?
Yes, we've got a plea, Judge.
Ms. Taylor, would you please raise your right hand to be sworn? You swear the testimony you give for his court's true, so help you God.
Yes, sir.
All right, you, Ms. Taylor, want to plead no contest to count 2, possession of drug paraphernalia. Is that going to be a misdemeanor? Is that,
I think it's a misdemeanor.
drug paraphernalia, isn't that a misdemeanor?
Yes, Your Honor.
Okay.
Count 2
And count 3 is a misdemeanor also, possession of controlled substance less than 20 grams of cannabis. And in count 1, felony, possession of controlled substance will be null prost, correct? Okay. So you want to enter a plea to that, and if you complete the PTI program, these 2 charges you're pleading to will be dismissed.
Yes, sir.
Okay. So you want to enter that agreement and that plea, correct?
Yes, sir.
Did you read and sign his plea and sentencing agreement form?
Yes, sir.
You understand the rights you're waiving by entering this plea?
I do.
Has anyone forced you or threatened you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Not at all.
Are you happy with the work Mr. Powell has done for you in the case?
Yes, sir.
If you don't complete the PTI, then you'll be sentenced according to this agreement. Do you understand that?
Yes, sir, I do.
And you understand the terms of the PTI you have to complete?
Yes, sir.
Mr. Powell has gone over that with you?
Yes, sir.
All right. Court finds the plea is freely and voluntarily entered. Court accepts it, and just complete the PTI program, and your charges will be dropped.
Yes, sir.
Thank
Okay.
you, Judge.
Thank
That's
you.
all I got.
Thank you.
And Your Honor, Mr. Powell provided us with the agreement. We will take it to the office instructor, and then we'll turn around and file it back with the court.
All right, thank you. Did we do Haney with Mr. Stewart? Oh, okay. Ms. Flowers? Okay.
Betty Westbrook. The docket for today, we were hoping we could get something worked out, but I think the state is in agreement. We're going to set her for December 7th to get restitution paid and go from there.
All right, Ms. Westbrook, we're continuing your case till December 7th, okay? Thank you.
And I have 2 inmates. Okay.
All right, this is Ramaya Custer.
Yes, Your Honor. Good morning. Jennifer Flowers with RCC on behalf of Ramaya Custer in 23 CF 2008, 20 CF 1039 is a VOP. We thought we might have a global resolution that included another new case that she has, 23 CF 2444, but that's not on today's docket. So in order to work on that a little bit further, I would ask to continue to the next.
I'm so sorry, Your Honor. Did you receive my last email? It's the same offer to include a new case. It's just 1 month more. Instead of 24, it was 25 months. DOC.
I didn't see that. Can I continue and talk to her about it?
Yes,
Okay.
yes.
We could set it for since this is a VOP, we can set it on like the next miscellaneous date.
You want to do it Thursday? Is that?
I'm not going to be here Thursday morning, so I'm having somebody cover for me. November 30th.
What about December 7th?
Or December 7th is fine with me.
Is that okay? All right,
And
December 7th.
Okay, thank you. Yep, you're welcome.
All right, December 7th.
I'll come to see you
then.
before that. Your Honor, this is Melissa Ann Sterner in 23 CF 795 and 22 CF 3157. That's a VOP. She's prepared to enter a no contest plea and admit the VOP today for an agreed upon sentence with the state, but we're asking to set out sentencing. It's not an open plea, it is an agreed upon sentence, so we're asking to impose that sentence at a later date on December 7th.
All right, Ms. Sterner, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God?
Yes, sir.
All right. You are in 23, this is State of Florida versus Melissa Sterner, 23 CF 795, 22 CF 1357. In 23 CF 795, you want to enter a no contest plea to battery on a law enforcement officer, third-degree felony. And then count 2, resisting with violence, will be dismissed by the state, correct?
At time of sentencing, it will, Your Honor.
Okay. And then on 22 CF 3157, you want to admit that you violated probation. Is that correct? Is that correct, Ms. Sterner?
Excuse me, sir? Could
You want to admit that you violated probation in 22 CF 3157 and plead no contest in 23 CF 795 to battery on a law enforcement officer, a third-degree felony?
Yes, sir.
And one of the counts will be dismissed.
myself, but yes, sir.
Did I swear her in already? Would you raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God. All right. Speak up a little bit. You
Yes, sir.
swear the testimony you give for is course of truth, so help you God.
Yes, sir. Yes, Your Honor.
Okay. All right, so did you read and sign this plea and sentencing agreement form?
Oh, did she not sign the back
I
page?
didn't.
We've gone
I don't
over the
recall
plea
signing
and
anything.
sentence agreement.
I got one signature, I need another.
Sorry about that, Your Honor.
You shouldn't be able to use this title to his benefit, you know. Okay.
Really sorry about that, Your Honor. I know the court's time is important.
It's all right. All right, did you read and sign this plea and sentencing agreement form, Ms. Sterner?
Yes, Your Honor.
You can put your hand down.
Yes, sir.
Are you aware of the rights you're waiving by entering this plea of no contest and admission of violation
Yes, sir.
of probation?
Yes, sir.
Has anyone forced you or threatened you to enter this plea or admission?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No, sir.
Are you happy with the work Ms. Flowers has done for you on your case?
Yes, sir.
Court finds the plea and admission is freely and voluntarily entered. Court accepts it. Will put off sentencing to December 7th. Is that when y'all wanted it? December 7th.
Okay. Thank you, Judge.
Okay. Y'all need this back.
Thank you.
Ms. Flowers, remind me what y'all agreed to. I'm going to file this with the court.
Okay.
Okay.
I think that'd be best, and then that way we can just pull it up on the day.
All right.
I have today, if I may be.
Yes, thank you. Mr. Stewart, did you have an?
Yes, Your Honor.
Okay. Hayes?
Mr. Haney, Haney, Your Honor.
Oh, Thomas Haney, okay.
And this is case number 22 CF 2759, Judge.
Okay.
If I can pause just for a moment. Your Honor, at this time, Mr. Haney is prepared to tender a plea of no contest to count 2, Judge. Can I approach with the plea and sentencing agreement?
All right, this is 2022 CF 2759, State of Florida versus Thomas Vincent Haney. Mr. Haney, would you please raise your right hand to be sworn? You swear the testimony you give for is course of truth, so help you God.
Yes, sir.
You want to enter a plea of no contest to count 2, possession of a weapon in violation of risk protection order, and then the state is going to dismiss count 1, possession of a controlled substance, and count 3, possession of paraphernalia, correct?
Yes, Your Honor.
And Mr. Haney, did you read and sign this plea and sentencing agreement form?
Yes, it is, sir.
You aware of the rights you're waiving by entering this plea?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here
No,
today?
sir.
Are you happy with the work Mr. Stewart's done for you on your case?
Very happy.
The court finds the plea is freely and voluntarily entered. Court accepts it. On count 2, the court's going to withhold adjudication, put you on 2 years probation, 515 court costs, $100 cost of prosecution, substance abuse evaluation with treatment, have a mental health evaluation with treatment, random UAs, no drugs or alcohol without a prescription. Probation is concurrent.
I'm sorry, Judge, we'd strike through that one.
I was going to say, okay, no probation current, but you forfeit the firearm and ammunition and waive cost of supervision, and counts 1 and 3 are going to be dismissed by the state.
Correct, Judge.
Correct.
And just to perfect the record, he is outfitted with a GPS monitor that can be removed today, pursuant to the agreement.
Okay, you can have that off.
Thank you.
Okay. All right.
Yeah.
Just get this probation done, okay? And,
Yes, sir.
all right. Thank you.
I'm gonna get the.
Do I need a score sheet on this?
Yes, Your Honor, I'll get it.
I anticipated hanging out for the rest of the morning with regards to working out the trial situation. Is that all right?
Yes.
I just need to
Yeah.
tell the bailiffs what to do with my client.
Okay.
Thank you, sir.
Charles Russell, Public Defender's Office. Judge, this is McKelton Lett. Case number is 21 CF 1977. If I might have a moment. Judge, on Mr. Lett's case, we wanted to leave it on the trial docket. I was just letting Mr. Lett know that the state's informed me that if we don't accept the state's offers today, that those offers will be withdrawn, and that's what I was telling Mr. Lett. So I'm not sure what he wants to do.
Want to bring him back in a little bit later on and think about it? Later today? You want to talk to your attorney about this offer again?
Do what I'm saying, Your Honor. I've been asking them back to back about when is they gonna come with the see about Alabama. Like it's still, he was supposed to come and see me. They ain't call. They called my name and then I guess he left. They want to come with the offer today, which I ain't even get to talk to him. They want me to talk to him now.
We'll continue it to December 7th. That's just a little while, and you can get it straightened out.
I'm trying to
Maybe.
figure out why they keep on it's back to back.
I got it, but
what can I do, man?
they need to check with Alabama. I think Alabama's delaying it, so we'll bring you back December 7th. See what you want to do. Okay?
For the record, Judge, it's the state's
Is the offer still open till the 7th?
Mr. Lett made us put on the offer, we gave him 2 other options. Those will remain open till the 7th, but that's the last day.
All right, see what you can figure out with this Alabama situation, Mr. Russell.
I'll go
Okay?
talk to him at the jail about it, Judge. I've already
All right.
talked to him about it several times, but
I keep telling them.
All right, well, you're going to go to trial or plead, one thing or the other, because the state's losing patience. They don't want to let you have a continuance, and I got to try the case or plead it one way or the other. You know, and I'm happy to give you a jury trial. We got some time this month, but your time is running. I mean, so see about what you want to do. I don't want you to risk a long sentence if you have a reasonable chance for something much less. And we'll go to trial if you feel like you just want to totally, go for the trial, and maybe you'll be found not guilty. I don't know, but we'll give you a chance. We'll bring you back December 7th. They're still leaving it open, the offer open until December 7th, okay?
and that'll be 9 o'clock, Judge?
Yes.
Thank you, Judge. Come see you. Charles Russell, Public Defender's Office. Judge, this is Robert Strauss. Case number is 21 CF 247. If I could have a moment. Mr. Strauss's case, Judge, we heard from one of our witnesses that she's recovering from open heart surgery. Don't know that she'll be available this trial cycle, and because of that, defense is going to ask for a continuance.
February 26th. Thank you.
Thank you, Judge.
Judge, I've got an out of custody that I can call back up. You heard him earlier, Darius Livingston.
Darius Livingston.
Judge, this is going to be a pretrial intervention.
Okay.
State doesn't have the contracts up yet, but believe that they can by Thursday, so if I can pass him until the 9th.
All right, Mr. We'll bring you back on Thursday the 9th, okay?
Thank you. I'm ready with...
Who's your first client, Mr. Mr. Williams?
Just start at the, yeah, everybody's else that I've got is in jail. I'm sorry, Judge. Judge, they've made a pretrial intervention offer for Ms. Airbearer. She wants me to meet with her one more time, go over discovery. I think we can get this resolved on Thursday, though.
Okay, November 9th.
Thank you, Judge.
Thank you. All right. And that's an offer for PTI?
Yes, sir, it is.
Ooh, sounds pretty good.
Judge, we had passed Mr. Costin today because he hadn't been brought down when I went out to see him before pretrial conference. I have seen him now, and I'm going to move to continue his case.
February 26th.
Thank you, Judge.
Move it up if we get it resolved.
Yes, sir.
Jared David Nichols.
Yeah, that's fine.
I've sent in 4 applications to them.
Judge, we'll just, instead of passing this a whole docket, we'll pass it till November 30th. We're just trying to see if we can get him in Phoenix House.
Okay, November 30th.
All right, no problem.
Thank you, ma'am.
Judge, this is Mr. Mays. I've had some further conversations with the state on this. I need to verify this particular officer. I'm going to try to do that on Wednesday when I go out for my regular jail visits. But I think we're going to have to pass Mr. Mays out. I don't know if the state would be ready to do her. You're going to want to talk to this guy yourself, aren't you? Okay. Let's pass him till November 30th then. I think we can get it all done by then.
All right, November 30th. See if we can get the case resolved. Thank you, sir.
Thank you, Judge.
What did we do on
Jared Nichols.
what did we do on Donald Langley?
Okay.
Was that continued? Donald Langley? Was that continued?
Yes, Your Honor.
What about Judith Dickerson, Mr. Nopes? Did we call that one?
Always in court. Here this morning, she was here Monday.
She's what?
She's always in court, and she was here Monday, and then I've just texted her, and I've called her, and she's not answering. She's an older person, you know. So
What were you
I'm
going to
worried
do with
about
the
her.
case?
Judge, I was going to ask the state to consider a counteroffer on what they were wanting her to enter a plea to, but without her here, I'm not able to really.
Want to move her to November 9th?
Judge, I think that would probably work. Let me just double check.
How about that, Miss?
November 9th, I'm going to be here anyway maybe it's with you. There's a hearing I've got on that day for the state's wanting to get medical blood, so I'll be here. Let's do that.
November 9th?
And then, Judge, the state and I've not had an opportunity to talk about Miss Matthews, so if we want to just put her on for the 9th, maybe we can clean it up by then.
November 9th? Okay.
Judge, that's all I've got.
Okay, thank you.
Your Honor,
Do we have?
may I approach this question on the two cases?
Yes.
Please, yes. This is the one with Ms. Rivers. For Ms. Person, she has seen it and doesn't have any objection. This is the one with Mr. Stewart, no objection after this.
So we have one trial so far set on jury selection November 20th. Start and do the trial the 21st. Yeah, what about Mr. Robbins? Who is he with?
The approach for coordination.
All right. I'm looking at probably November 13th on that. I don't know how else we can do it.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Briar Patch Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
CQ Roofing, your hometown roofer since 1999. We're state licensed and insured, family owned and operated with 24 years of local service. We specialize in shingles and metal, re-roofs, repairs, and leak specialists. For all of your roofing needs, call us today or visit our website at cqroofing.com. CQ Roofing, your hometown roofer.
Dave's Tire Pros makes buying tires simpler. They offer a straightforward approach to tire and auto service that includes nationwide warranties, a hassle-free experience, and a great selection of Michelin tires. No matter what you drive or where you have driven, Michelin has a tire to fit any need. Visit our store in Crestview or online at Dave'sTirePros.com. Tire Pros love the drive.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alex Barthay from the UPS store once again, and I wanted to let you know about our Sunday hours. We're open now 7 days a week. Normal hours that you've been expecting, but now we're open Saturday 10 to 4, Sunday 10 to 3, and that's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
What can I help you with?
I think I was bit by a vampire.
This is definitely concerning, but I don't have any experience with vampire bites. I do, however, have training in accident investigation from the Florida Highway Patrol, and I'm proud to say that I've received many awards that... Hey, you feeling okay, buddy?
Injured? Take a breath. Call Coy.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us
Okay? Thank you. Who do we have, ladies back there? Who y'all waiting on?
They're waiting on me, Judge. We're working a couple last things out.
Okay. What about Wesley Beitler?
Judge, we had put him on today's docket because we thought he had been released from the jail after he was ordered to go to Phoenix House as part of a new probation. Because he wasn't released, we don't need to call him. We can just take him off the docket. He's already been sentenced and is waiting transport to Phoenix House.
Jessica Carroll.
Judge, she is in jail. I can call her. Yeah, we just want to make sure that from last week, for Mr. Beitler, that his minute sheet does say bars to bed. That was the intention of that plea.
I think I signed something.
You may have.
There was a Elm girl who we've already done. We can take care of her, and Butler was in the same position to stay in custody until it's picked up from Phoenix House. Picked up by Phoenix House.
What did we decide? I forgot on Devin Robbins. Just continue that. Yeah, okay. Jessica Carroll. All right, Jessica Carroll. You're Jessica Carroll?
Yes, sir.
Thank you.
Judge, I believe we have reached an agreement in this case. We had requested from the state if we could do a 2-year suspended sentence with 3 years of probation. That would be a downward departure for a legitimate and coerced plea bargain. I haven't had the opportunity to reduce this to writing. If the court require it in writing, I can certainly write that up. Otherwise, I'm happy to have it on the record.
What was the plea?
Judge, in this case, she would enter a plea of no contest. The agreed-upon sentence would be a 2-year suspended DOC sentence, conditioned on successful completion of 3 years of probation. She would have to pay the court costs. I believe she would also need to undergo a substance abuse evaluation and treatment if recommended. Certainly a preference for the Emerald Coast Life Center, where we can give her that contact information, as well as probation can give her that contact information. I'm not sure if there is any restitution, but we are happy to reserve on that issue for 120 days.
Yes, please.
In the event that there is any restitution, and we can handle that after that time, or before that time.
All right, Ms. Carroll, would you please raise your right hand and be sworn? You swear the testimony you give before this court is the truth, so help you God?
Yes, sir.
All right, this is 23 CF 1531, State versus Jessica Carroll. You want to enter a no contest plea to the charge of resisting an officer with violence, a third-degree felony?
Yes, sir.
Anyone force you or threaten you to enter this plea?
No, sir.
Are you aware of the rights you're waiving by entering this plea?
Yes, sir.
Right to a trial, make the state prove its case beyond a reasonable doubt, right to remain silent, right to testify, right to cross-examine witnesses, all
Yes, sir.
those and other rights. You understand all your rights you're waiving by entering this plea?
Yes, sir.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
Absolutely not.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes.
Court finds the plea is freely and voluntarily entered. Court accepts it. Sentences you to 3 years probation with a 2-year suspended Department of Corrections sentence. Standard court costs. Reserve on restitution for 120 days. Have a substance abuse evaluation within 30 days and complete any recommended treatment. Anything further? Withheld, or I got to adjudicate her on that? Adjudicated. All right, thank you. Supervision fees waived.
Score sheet, Judge, without objection.
Your Honor, on her, with all the holidays coming up, we're going to send her for the evaluation. But what's happening at our office now, if they're not down there within 30 days, we're having to send you a technical violation letter.
We can amend it to where she enters and completes Emerald Coast Life Center. I know Ms. Claw would be able to meet with her.
Okay.
Yeah, we can just make that the condition instead.
So with that, Judge?
Yeah.
It's still outpatient. Yeah, we have the preference for it, so we can order that. Good with that?
All right, thank you. Rocky Carter.
Your Honor, Tim Gibbs on behalf of Rocky Carter. This is 23 CF 800. As the court may recall, we had a VOP trial a few months ago. We were gearing up to see if this case would end up going to a jury trial or if we were going to reach any kind of agreement. Judge, we have not been able to reach any kind of agreement. I have been working on it. I've been explaining to Mr. Carter the options that he has, whether it's to accept the state's offer of a 30-month coterminous sentence, to enter a plea to the bench, or to proceed to a jury trial or a judge trial if he decides. I'm not sure that Mr. Carter is ready to make a decision on that. We did have him evaluated, as the court may be aware. Dr. Zeman opined that he is competent to proceed. However, I still have some concerns in that area. He does have a lot of medical conditions that I believe are still making it to where he's having difficulty making that decision, fully understanding the situation in which he finds himself. He also had mentioned earlier that he may want a different attorney. He hasn't put any of his complaints in writing, which would be required for the procedure on a Nelson hearing. But I'm happy for the court to inquire about that, or otherwise we would probably need to continue this case potentially for a second competency evaluation.
February 26th. Thank you. He's been found guilty of violation of probation, correct?
This court's already sentenced him to 30 months in those cases.
And if you work out a deal, I'm probably, unless the state, were you offering coterminous 30 months?
Yes, Judge, I was. I am offering coterminous.
They're offering you a deal that you're going to get out the same time as when you get out your probation or violation sentence.
Is it okay if may I speak, please? I'll be real short and blunt about it. Your Honor, I apologize for being in your courtroom. I'm 65 years old with heart disease and epilepsy. I've been fighting since I was 15 years old. All these scars on me are from having seizures, the worst ones ever. And my heart is shut down twice because my main artery is messed up. I apologize again for all this trouble. And a few things I don't understand. I've gotten no written papers or paperwork or points or depositions of any sort from the court. I've seen no paperwork. And I'm really confused because all I did was try to help a 61-year-old girl get off of drugs.
Don't talk about the facts of your case.
Hey,
don't talk about the facts of your case. Okay. Everything's being recorded. Your statements can be used against you later.
And anyway, I failed. So I was willing to take the violation of probation because I was discussed with the law. I had talked to the law and got arrested. I'd be willing to take that. But I did not ever. I'm a good man, Your Honor. I'm really a good country boy. I don't beat people up. I don't use guns. I've never owned a gun. All I know how to do is catch fish and grow vegetables and work real hard. I would never threaten anybody over a cab ride. That's ridiculous. That don't even sound right coming out of my mouth or anyone else's. All I did was get released from jail, walk to the bank,
talk about the facts of your case because everything
I was
is being
asking for a
recorded.
cab. And that's all. But I'm willing to work a deal with the state, and Mr. Gibbs has been working hard, but he's loaded with cases. And I'm just trying to work things out because I don't want to have a stroke or another heart failure in your jail. I really don't. I had
Bring it back November 9th and see if you can work out a plea.
Okay.
But
November 9th,
to make it as clear as possible, if I understand, if you enter a plea, you're going to get the same sentence that you've already been sentenced to. Nothing worse, correct?
Judge, for the record, the offer that the state extended was for 30 months coterminous, so he would not be serving any additional time beyond what the court has
already imposed. If you enter a plea, you're not going to get any additional time.
Well, yes, sir, Your Honor. And I saw Dr. Zeman, and he was concerned about me. He said I seemed delusional and delirious because of my epilepsy. And he asked me what the state recommended. I told him 30 months. And he says, I'm going to recommend a suspended sentence and a downward departure. He said he was going to contact you and
he ain't going to recommend nothing like that because he's not
the words
an
he
attorney.
told me at the jail.
That's also not the evaluation that we received, Judge. It was a competency evaluation.
Well, like I said, you got 30 months. I already sentenced you to 30 months. I'm not going to give you any more than 30 months if you want to enter a plea. But you have a right to go to trial. You might get found not guilty, but if you're found guilty, you run the risk of getting a lot more than 30 months. Okay? Thank you. November 6th.
We'll see you Thursday, Judge.
November 9th.
See you Thursday.
Brian William Crocker, okay?
Judge, we've reached an agreement. We just need Mr. Crocker to review it and sign his
Okay.
agreement. So. That's what you want to do, if you would please. Right there for me. Yes, sir. Your Honor, if I may approach.
All right, you're Brian William Crocker?
Yes, Your
Would you
Honor.
please raise your right hand and be sworn? You swear the testimony you give before this course of truth, so help you God.
Yes, sir.
Thank you. You can put your hand down.
Your Honor, that score sheet is included. This would represent a downward departure for a legitimate uncoerced plea bargain.
All right. In 22 CF 978, Mr. Crocker, you want to admit that you violated probation. In 22 CF 1950, you want to admit that you violated probation. And in 23 CF 626, you want to enter a no contest plea to possession of a controlled substance, a third-degree felony, and possession of paraphernalia, first-degree misdemeanor. And on 23 CF 2630, you want to enter a no contest plea to battery on emergency medical service person, 2 counts, both third-degree felonies, and a count of criminal mischief, a third-degree felony. So you want to enter a admission and no contest plea to those charges, correct?
Yes, Your Honor.
Did you read and sign this plea and sentencing agreement form?
Yes, I did.
Are you aware of the rights you're waiving by entering this admission and no contest plea?
Yes, sir.
Has anyone forced you or threatened you to enter this plea?
No, Your Honor.
Are you under the influence of any drugs or medication that prevents you from knowing what you're doing here today?
No, Your Honor.
Are you happy with the work Mr. Gibbs has done for you on your case?
Yes, I am, sir.
Okay. Court finds the admission and plea is freely and voluntarily entered. Court accepts it. In 22 CF 978 and 22 CF 1950, the court's going to revoke and terminate probation, sentence you to time served. $200 cost of prosecution total, $250 PD fee total, payable upon supervision with the other cases. In 23 CF 626, count 1, 2 years community control, $100 cost of prosecution, $515 court costs, $100 PD fee. And you are to go to the Emerald Coast Life Center for what?
That's a treatment program, Judge. It's
Treatment,
an outpatient
okay.
program.
And on count 2, that you are sentenced to time served. On count and 23 CF 2630, on all counts, concurrent, you're sentenced to 2 years concurrent sentence, $100 cost of prosecution, standard court costs, $100 PD fee, reserve on restitution for 120 days, waive cost of supervision, and all supervision on all counts, all cases is concurrent.
And that's 2 years CC on 23 CF 2630, Judge, right?
Yes, 2 years community control concurrent.
Thank you, Judge.
And adjudication on all cases, all counts.
Thank you, Judge.
thing, do we have to add the curfew time for CC or no?
It's automatic.
No, thank you.
Okay.
Yeah, but just that you're stuck at home.
Oh, okay. I can work.
Yeah, you can work. They'll explain that to you.
All right, thank you, sir.
Thank you,
Thank
Your
you, Judge.
Honor.
Judge, out of custody, I still have Miss Miranda Ballantyne. Judge, Miss Ballantyne is present and approaching.
Okay.
This is 22 CF 1807. Judge, I think we're still set for trial on this one, potentially for the week of the 20th, if I'm not mistaken.
Yes.
So do we want to bring her back on Thursday to confirm that it's going to be going that week?
Yeah.
Yes, Judge.
Okay.
So we'll come back on the 9th, Judge, this Thursday.
Yeah.
Yeah. Judge, if necessary, I'll waive her appearance that day and inform her she has a prior engagement, apparently, that she's unable to be here for. But I'll be able to confirm with her that.
No, she's got to be here.
I have to be at the Walton County.
So you got to be here too. I don't know, but you got to be here too if you want to go to trial.
We're meeting tomorrow, right? All right. Thank you, Judge. Next, Judge, I have Miss Stacy Flynn.
Lynn?
Yes, Your Honor. Judge, this is 23 CF 1453. She is present and approaching. Judge, I have not reduced an agreement in this case to writing, but I do believe we have an agreement. Judge, I believe the state would be over the side.
I'm sorry.
The state, in exchange for a plea to the possession of paraphernalia on this case for an adjudication of guilt, time served in court costs, I believe the state would also be willing to dismiss the felony count as well as the driving on a suspended license count.
That's correct, Your Honor.
Is the possession of paraphernalia a lesser included offense of count 1?
It was separately charged as count 3, Judge.
Yes, so state will dismiss count 1 and 2, and defendant pleads to count 3.
And that's going to be a misdemeanor?
Yes, Judge.
All right. Ms. Flynn, would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God.
So help me God.
All right. This is 23 CF 1453, State of Florida versus Stacy Flynn. You want to enter a no contest plea to a misdemeanor possession of paraphernalia at count 3, and the state's going to dismiss count 1 and 2, a felony and a first degree. Is that a misdemeanor also? Count 2?
Count 2, driving on a suspended license, was also
All
a
right.
misdemeanor.
A felony and a misdemeanor they're going to dismiss in exchange for a plea to possession of paraphernalia. You understand that?
Yes.
Are you aware of the rights you're waiving by entering this plea?
Sure am.
Anyone force you or threaten you to enter this plea?
No.
Are you under the influence of any medication or drugs that prevent you from knowing what you're doing here today?
No.
Are you happy with the work Mr. Gibbs has done for you on your case?
Definitely.
Court finds the plea is freely and voluntarily entered. Court accepts it and sentences her to, what was the agreement?
Just time served in court costs, Judge.
Sentence you to time served in the county jail and standard court costs and go to a judgment within 180 days. So you got 180 days paid or it goes to a judgment.
Total should be about 370.
Gotcha. Thank you.
Very well.
Thank
Okay.
you very much.
Thank you.
Next, Your Honor, I have Miss Heather Graves. Your Honor, Miss Graves is present and approaching. This is 22 CF 455.
You see that letter, Mr. Gibbs?
Yes, she has a copy of it.
Okay, yeah.
All right, this is Heather Graves.
Your Honor, we have reached an agreement for Ms. Graves to enter the pretrial intervention program. I do have a copy of that signed agreement.
This is 22 CF 455, State of Florida versus Heather Regina Graves. You're Heather Graves?
Yes, sir.
Would you please raise your right hand to be sworn? You swear the testimony you give for is course the truth, so help you God.
I may. It does not require a plea, Judge.
All right. So you're given a chance to enter the PTI program. And if you complete it, is the state going to dismiss the charges if she completes this?
Yes.
Okay.
It's just a substantial amount of restitution in the case, Judge. That's why the term is so long.
Yeah, I was going to say, it's,
At the rate that's
is that,
listed
I was going to say, is that the rate, is she going to make it within 36
yes,
months?
Judge. When I calculated it previously, that rate, that puts her at a little bit more than what the restitution is owed.
Okay.
So that if she keeps that rate, she would make the restitution.
All right, so you got 36 months to get this paid off, okay? All right, and the charges will be dropped, so it's worth it. Thank you.
Thank you, Court. Thank you, Judge. So you'll meet with them. Yeah, we crossed that off. We crossed off this 4% surcharge. That would be a lot more. Judge, the only other client that I had on today's docket was Courtney Ard, this on 23 CF 862, 23 CF 863. She has unfortunately not been able to get a ride to court. We have been in regular communication this morning. She's been updating me trying to get a taxi and sent me screenshots of people that she's been trying to call to get a ride here. I had set her for today in the hopes that I could meet with her, but I have been in communication.
What's her
with
name?
Courtney Ard. She is number 22 on my docket, Judge. I'd request the court to excuse her appearance today and continue this case again. We have been in regular communication.
Where does she live?
She lives in a rural area between here and Defuniak Springs, so it's very difficult for her to get signal as well as a ride often.
I can issue a capias and the sheriff will go get her and bring her.
I'd certainly request that the court did not do that, but of course that is the court's discretion.
Is this case going to get worked out, you think?
I have she sent me some items that we're going to review and send to the state that hopefully will help resolve the case, Judge.
When do you want a continuance to?
We could do a status for November 30th.
All right, November 30th. If she don't show up, I'm going to send a sheriff taxi to pick her up.
Understood.
She'll get free boarding for a while in the county jail.
Understood, Judge. Thank you very much.
Everyone's got transportation problems.
Thank you, Your Honor. That concludes my business.
All right. So what do we have? We got things this afternoon. Why don't we have some motion in limine or something this afternoon? Or what case was that on, Mr. Stewart?
That's on Mr. Roca.
Oh, okay. So that is, that's going to be, how long is that going to take?
That's a great question, Judge. It applies to the videos themselves, so I would tender that question to my...
You set for trial November 30th, correct?
What's that, Judge?
We are set, Your Honor. We could do the hearing right now on the motion in limine if Mr. Stewart is ready.
I can be ready in 10 minutes. I can go get my file, Judge.
All right, well, why don't we take a 15-minute break?
Okay.
And then, now I have down 5 days on Mr. Roca. So 1 day is jury selection. We got to get it done in 4 days, correct?
Yes, Judge.
Correct.
Okay. Y'all want to do it? All right. We'll take a break till 11.
Yes. May I just ask, Madam Clerk, please,